Okay, what are the crimes called malversation of public funds or property? So they are malversation by appropriating, misappropriating, or permitting any other person to take public funds or property, failure of accountable officer to render accounts, failure of a responsible public officer to render accounts before leaving the country, illegal use of public funds or property, failure to make delivery of public funds or property. Article 217, malversation of public funds or property. Presumption of malversation. Any public officer who by reason of the duties of his office is accountable for public funds or property shall appropriate the same, or shall take or misappropriate, or shall consent, or through abandonment or negligence shall permit any other person to take such public funds or property wholly or partially, or shall otherwise be guilty of the misappropriation or malversation of such funds or property shall suffer 1. The penalty of prison correctional in its medium and maximum periods if the amount involved in the misappropriation or malversation does not exceed 200 pesos. So up to 200 pesos lang, prison correctional and its medium and maximum periods. Takot ako po din nga imprisonment o 200 pesos lang. Second, the penalty of prison mayor in its minimum and medium periods if the amount involved is more than 200 pesos but does not exceed 6,000 pesos. So 200 to 6,000. Third, the penalty of prison mayor in its maximum period or reclusion temporal in its minimum period if the amount involved is more than 6,000 pesos but is less than 12,000 pesos. So it's more than 6,000 pesos but not equal to 12,000 pesos. Up to that point lang, no? The penalty of reclusion temporal in its medium and maximum periods if the amount involved is more than 12,000 pesos but is less than 22,000 pesos. If the amount exceeds the latter, the penalty shall be reclusion temporal in its maximum period to reclusion perpetua. So if you can misappropriate more than 22,000 pesos, 22,000 pesos or more, maabot kang reclusion perpetua ang imuhang imprisonment. That's why, aside from reclusion perpetua and death, na punishment, kung mapriso ka, madakpan ka na kaso, tapos more than 22,000 ang imuhang malversation, and non-bailable siya, wala siya bail, ang butandri din, not necessarily non-bailable, but ang usually ang gawas nga information sa city prosecutor's office kanang no bail recommended gani, so di ka gagawas kay more than 22,000 pesos yung nakuan misappropriate unless mo file ka petition for bail. But this one, as all other cases involving money, no, na yung mga amount nga more than the threshold, kaya ang penalty na maabot na siya reclusion perpetua. That's why when the prosecutor who would examine as to the existence of the probable cause of the offense, whether or not guilty ang accused sa probable cause ana, and the findings of the prosecutor is such that mag-recommend po na sila kung nakabutan nito no bail recommended. Just like the penalty of reclusion perpetua o death, wala gina siya bail. As per law yun, wala gina siya bail. And non-bailable gina siya ng mga offenses. So kani mga lower than death and reclusion perpetua, pasaaning embezzlement involving amount of money na siya reclusion perpetua nga range, no? So that's why the prosecutor will say no bail recommended. In all cases, persons guilty of malversation shall also suffer the penalty of perpetual special disqualification and a fine equal to the amount of the funds malversed or equal to the total value of the property embezzled. So take note sa wordings na applicability niya. Pag mention ka o malversation, it really means amount of money involved which is misappropriated by the public officer. But if he squandered properties, dili siya malversation, tawag embezzlement. Embezzled. Take note of the wordings, ha. The failure of a public officer to have duly forthcoming any public funds or property with which he is chargeable upon demand by any duly authorized officer shall be prima facie evidence that he has put such missing funds or property to personal uses. So take note of the word upon demand. So kung nag-demand gani niya, dili ka ka-present sa accountability nimo, naana siya presumption na misuse nimo, na personal use nimo ang property. In that case, you would be guilty of embezzlement and all or malversation. What is embezzlement? Malversation is otherwise called embezzlement. Note the word embezzle in the phrase or equal to the total value of property embezzled in the penultimate paragraph of Article 217. So malversation is otherwise called embezzlement. Kaya lang, ito lagi, wala na ang application. In general, malversation is to the funds involved. Embezzlement is to the property involved. Acts punishable in malversation by appropriating public funds or property, by taking or misappropriating the same, by consenting or through abandonment or negligence permitting any other person to take such public funds or property, by being otherwise guilty of the misappropriation or malversation of such funds or property. So these are the 4 ways in malversation that are to be punished. The penalty for malversation is the same whether committed with malice or through negligence or imprudence. So as we all know, we learned that when a crime is committed with malice, naging siya intention. But otherwise, wala siya intention, but the crime was committed nonetheless. Could it be that the same has been committed through negligence or imprudence? Usually, pag a crime is committed through negligence or imprudence, the penalty is lesser, lesser ang effect or penalty nga equal sa iyaha, ihatag sa iyaha. But in the crime of malversation, the same, the same ang penalty whether the crime is committed intentionally or with malice, or that it is being done through negligence or imprudence. This is the exception to the provision of Article 67, which provides penalties similar to those provided in Article 366, defining and penalizing with lower penalties culpable felony or criminal imprudence. So common elements to all acts of malversation are the following: that the offender is a public officer, that he had the custody or control of funds or property by reason of the duties of his office, that those funds or property were public funds or property for which he was accountable, that he appropriated, took, misappropriated, or consented, or through abandonment or negligence permitted another person to take them. So take note of these elements, But pinaka-basic diha, that the person who committed the malversation is a public officer. Kung dili siya public officer, dili siya commit ng malversation, lahat to ang iyang commission to estafa or another crime, that not malversation. Kaya malversation is open lang on sa mga sa mga public officers or employees. And then another thing to think about is that the funds or the property is public funds or property. Because if it's private funds or property, dili po siya commit malversation even if he is a public officer. Read the examples, What are considered public funds? My example, Red Cross Anti-Tuberculosis Society and Boy Scouts funds received by Assistant Cashier of the Provincial Treasurer by virtue of his official position for custody acquired character of public funds. So, sa Red Cross man go, dili man go na siya government agency ang Red Cross. Pero pag nakadawat ka ng funds gikan ana by reason of your office, then it becomes public funds ang ginahatag sa imong kwarta. Postal money orders being the nature of public funds. Money received by sheriff as redemption price. Money received by sheriff to indemnify him against any claim for damages that might arise in connection with the levy made by him upon property belonging to a judgment debtor is a government fund. NARIC funds received by a municipal treasurer as ex officio in charge of the funds of the NARIC in the municipality. Proceeds of sale of sweepstakes tickets. Sa mga public property, firearms or explosives seized from persons not authorized to possess the same, which are in the custody of peace officers, are public property. Materials, chiefly timber of the Bureau of Commerce and Industry, which are in the custody of abandoned warehouseman, are public property. Well, in some cases, private property may be involved in malversation. So the provisions of Article 217 apply to administrator or depository of funds or property attached, seized, or deposited by public authority, even if such property belongs to a private individual. In that cases, some instance only. By the way, let's discuss malversation through abandonment or negligence. What is negligence? What is the test to determine negligence? Negligence is the omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or the doing or something which a prudent and reasonable man would do, The test by which to determine the existence of negligence in a particular case may be stated as follows. Did the defendant in doing the alleged negligent act use that reasonable care and caution which an ordinary prudent person would have used in the same situation? If not, he is guilty of negligence. Pinaka-perfect example, ani, is if you are a cashier sa government office, and then you left your office, leaving behind your safe, and which is open. Kalimutan niya ba open, and then this is the money and the properties inside are open to the eyes of the public, and the public can easily reach the money or property dito sa safe niya. Well, kung mawala, pagbalik niya nawala, since i-open man niya, kisay nakawala ato. Yan ang pinaka-perfect example, ana. Usually, kuan man gina is open man gina pag gawas ka din mo sa imong opisina, dapat sirado tanan, naka-save tanan na imong mga property dia. Accountable for that. Dapat you should be conscious that when you return, you have to account for all the properties under your custody, and the content of the safe are properties or funds under your custody. So dapat you should be conscious of that. The moment you left your work area and then letting the properties and money inside the safe be exposed to the public because you failed to close the safe, then that would be your negligence then, no? If this money and the properties are lost afterwards, then it's your negligence. The law here, in effect, adopts the standard supposed to be supplied by the imaginary conduct of the discrete paterfamilias of the Roman law. The existence of negligence in a given case is not determined by reference to the personal judgment of the actor in the situation before him. The law considers what would be reckless, blameworthy, or negligent in the man of ordinary intelligence and prudence, and determines liability to that. Usually, ang negligence pagod, as being stated here, are that in every case, there's unique findings of negligence to that particular person. In every instance, no two situations are the same when you have to determine negligence of that particular person, of a responsible person. No two situations, no, dili tanan pare-pareha, kay na mga circumstances that would differ from the other, and that you would even if the same circumstance, pare-pareha situations, but you would not give the same findings of negligence for one situation to the other based on that particular circumstances, differing circumstances. Maybe the same situation but differing circumstances. So negligence could be ascribed lesser than the other and greater than the other. The measure of negligence is the standard of care commensurate with the occasion. Kung nana mo alam pa mo ani ka ginang obligations and contracts, no? Because obligations and contracts, if you are given some property or funds in your custody, and there is no agreement as to the degree of care that you should provide in order to take care of the particular properties or funds, the diligence intended to that of the good father of the family shall be applied, no? Unless na agreement that it should be extraordinary diligence, or you would agree ordinary diligence only, or you would agree diligence of a good father of the family. There are several levels, eh. First, ordinary diligence and diligence of a good father of the family, and then afterwards, extraordinary diligence. Extraordinary diligence, extra care ka na yun, dira. Every time that you have consciousness about the custody of your thing, you have to be thinking about how you are going to do things in order to protect and maintain the integrity and safety of your property or funds under your custody. Ana na yun ang kagrabe na extraordinary diligence. But if there is no agreement, then the diligence of a good father from the family will still apply. To measure the negligence which pervades a particular act or omission, we must first determine upon a standard of care commensurate with the occasion, and then endeavor to ascertain how far short of this standard falls the act or omission in question. That's where a municipal treasurer to whom was entrusted for safekeeping an opium pipe confiscated by the authorities put the said pipe in the drawer of an aparador in his office, and the office was kept locked. It cannot be said that he abandoned the property when it was stolen from the aparador. Okay, the return of the funds malversed is only mitigating circumstance, not exempting. But take note of this, even if you have already returned after you have used the property or funds for your personal use, even if you return it, it's only mitigating circumstance, not exempting, because the crime has already been committed when you use the property, you make use of the property personally. When his books were examined by the auditor, the assistant cashier in the provincial treasury could not produce the amount. Later, the assistant cashier offered to do and did actually return the money. The return of the money was merely a mitigating circumstance. It cannot exempt him from criminal liability. Where the partial restitution or restoration of the shortage was made 7 years after the swindling took place, and after one of the accused was already convicted, there is no prompt refund of the shortage, and the accused cannot be credited with mitigating circumstance similar and analogous to voluntary surrender. There must be prompt refund of the shortage. When the shortage is paid by the public officer from his pocket, he is not liable for malversation. It should be prompt, no? Not necessarily after a long period of time. Borrowing money to replace missing funds with not malversation. The fact that the amount in cash which the municipal treasurer should have in his cafe was fully covered by an amount borrowed from one of his clerks does not relieve the said treasurer from criminal responsibility, as he did not explain satisfactorily why the amount which should be in his hands was in his clerk's possession. The presumption is that he misappropriated the missing amount. Okay, demand not necessary in malversation. Previous demand is not necessary in spite of the last paragraph of Article 217. Okay, nagbasa tayo kanina sa 217, I mentioned that there should be demand, no? But here, under this particular rule, under the Supreme Court case, the last paragraph of Article 217 provides only for a rule of procedural law, a rule of evidence, and no more. Demand merely raises a prima facie presumption that missing funds have been put to personal use. The demand itself, however, is not an element of and not indispensable to constitute malversation. So, despite na walay demand, but there's already findings of malversation, then the crime has already been committed. Article 218, failure of accountable officer to render accounts. So once there is this particular expenses and you have to disburse some kind of funds, you have to support these disbursements with official receipts and other supporting documents. That's basic yun siya, no? Even if you are a public officer, you should know that. Even if you are only an agent or say private person being entrusted with funds, the most podigos, the most judicial thing that you should do after you have spent all the funds given entrusted to you is to account these funds, no, to the person who entrusted the funds to you, so that the trust would still be there, no? Continuous ang trust sa imuha, and later on in the future you still could be accounted or could be entrusted with several funds bigger than what he has entrusted to you at this particular time. So yun lang ang pag-build ng trust eh. Once you are given such funds, you should spend it judiciously and make effort to present all the supporting documents, official receipts of where the money goes, no? Imong kita siya ipakita sa imuang amo, whatever, so that the trust would continue. Just like much more kung public officer ka, because the accounting is inherent in your being a public officer. You should account for all the money and properties entrusted to you. Any public officer, whether in the service or separated therefrom by resignation or any other cause, take note Bisa naka-separate na ka, pwede pag yung kapangayuan, paninglan sa mga public funds o properties nga in your custody, even if you have resigned, no? So, therefrom, by resignation or any other cause, who is required by law or regulation to render account to the insular auditor, is actually commission of audit, or to a provincial auditor, and who fails to do so for a period of 2 months after such accounts should be rendered, shall be punished by prison correctional its minimum period, or by a fine ranging from 200 to 6,000 pesos or both. Well, guys, take note as I said, if you are a public officer, continuous siya accounting. Once you are being entrusted with some kind of funds or property coming from public funds or property, then you have to continually make some accounting of how you spend or use such property or fundings. Continually na. How much more if you are going to resign or you be separated, no? Because that would be constituting your procedure, a procedure to acquire clearance from being separated from office. You would not be cleared if you would not have given all the accounting for all the funds and property entrusted to you. Yan yun eh. So, dito sa Article 218, may period talaga, 2 months after such account should be rendered. Meaning, well, before you resign, before the effectivity of your resignation, you have to make an accounting. No? That could be the day where when the 2 months period shall be reckoned. No? You have to make an accounting. So, pag-count ni mo na such account should be rendered, shall be punished by prison correctional its minimum period, or by fine ranging from 2,000 to 6,000 pesos or both. Take note of the presumption pag di mo makuha na 2 months, pasabot ikaw, gigamit na mo. So the elements is that the offender is public officer, whether in the service or separated therefrom, that he must be an accountable officer for public funds or property, that he is required by law or regulation to render accounts to the Commission on Audit or to the Provincial Auditor, that he fails to do so for a period of 2 months after such accounts should be rendered. Again, demand for accounting is not necessary under Article 218. Even misappropriation is not even necessary, no? It is not essential that there be misappropriation. If there is a misappropriation, he would be liable also for malversation under Article 217. Article 219, failure of a responsible public officer to render accounts before leaving the country. How much more, no? Render mo ganun siya account, wala siya mo leave the country, just resignation or just retirement. Ano pa mo ato ka, gawas ko sa laing sa country. Any public officer who unlawfully leaves or attempts to leave the country, this is what we call, abscond to abscond actually. This is what we call to abscond. Public officer unlawfully leaves or attempts to leave the Philippine Islands without securing a certificate from the insular auditor showing that his accounts have been finally settled shall be punished by Arresto Mayor or a fine ranging from 200 to 1,000 pesos or both. Natin pa lang, di yung kagawa sa ana. Pero if you have leave the country, pagbalik ni mo, preso ka yun. So kung matim ka lang, pwede pa ka masakpan, pwede ka ma-arrest, wala kay clearance, di ka sa Commission on Audit. Pero pag nakagawas ka na, wala ka clearance sa audit, pagbalik ni mo, you have already been, you would not know you have already committed this particular offense. It's Article 219, failure of a responsible of public officer to render accounts before leaving the country. Article 220, illegal use of public funds or property. Any public officer who shall apply any public funds or property under his administration to any public use other than for which such fund or property were appropriated by law or ordinance shall suffer the penalty of prison correctional in its minimum period, or a fine ranging from 1/2 to the total value of the sum misapplied, if by reason of such misapplication any damage or embarrassment shall have resulted to the public service. In either case, the offender shall also suffer the penalty of temporary special disqualification. If no damage or embarrassment to the public service has resulted, the penalty shall be fined from 5 to 50% of the sum misapplied. Take note that the funds are still used for public use, no? Ani ginatawag nila og technical malversation. Technical malversation ang tawag aniya So even if, okay, the funds are public funds. The property is public property, the government property. And you know, when the funds and government properties are there, they are existing because some kind of budget has allocated them for such, no? And sa budget pa lang, ay mga budget nga, mga considerations eh. These properties belong to this and should go through this, and it should be used for this particular purpose. Wala ang allocation sa budget nila. Every year, yun na yung mga allocation. So, if these funds and properties arrive to your custody, sa hands mo, and then specifically merong purpose doon saan gamitin mo sa paggagamitan. Huwag mong gamitin sa iba na purpose, no? Like another project, because that would now be constituting technical malversation, no? There's no technical malversation if there's no law or ordinance appropriating public funds or property for a particular purpose. So, okay. In the absence of law or ordinance appropriating the public fund allegedly technically malverse, in the absence of law ordinance, no? The use thereof for other public purpose will not make the accused guilty of violation of Article 220 revised Penal Code. Take note, ha? Among siya unappropriated funds, okay lang siya bisang asa lang siya iutang. Na ay mga funds set aside, unappropriated ang tawag. Ka-budget na siya for kind of tawag like emergency contingency funds. Pwede na sa bisig asa i-apply. Pero kung funds nga kanilang, diya gano'n siya pwede. Diya gano'n siya igastuhon. Pag gamiton niyo mo lang sa laing project, yan, technical malversation ka, you will be violating Article 220 of the revised Penal Code. So let's go to Article 221. Failure to make delivery of public funds or property. Any public officer under obligation to make payment from government funds in his possession who shall fail to make such payment shall be punished by arresto mayor and a fine of from 5 to 25% of the sum which he failed to pay. This provision shall apply to any public officer who, being ordered by competent authority to deliver any property in his custody or under his administration, shall refuse to make such delivery. The fine shall be graduated in such case by the value of the thing, provided that it shall not be less than 50 pesos. So, take note, ha, na require ang isang public officer to make payment from government funds in his possession. Wala niya na failure, there's failure to make such payment, or to deliver any property in his custody under his administration, refuse siya to make such delivery. So, nanay mga fines, nanay mga penalty. So, the acts punished under Article 221 by failing to make payment by a public officer who is under obligation to make such payment from government funds in his possession, by refusing to make delivery by a public officer who has been ordered by competent authority to deliver any property in his custody or under his administration. Let's go to Article 222. Officers included in the preceding provisions. The provisions of this chapter shall apply to private individuals who in any capacity whatever have charge of any insular or national, provincial, or municipal funds, revenues, or property, or to any administrator or depository, or funds, or property attached to or deposited by public authority, even if such property belongs to a private individual. Take note, ha, bisang pag private individual ka, pero nakagunit ka aning mga national, provincial, or municipal funds, you will still be liable for those articles which we have mentioned, malversation and embezzlement. So, kisa man yung mga example ani. Okay, so purpose Article 222. The purpose of Article 222 of the revised Penal Code is to extend the provision of the code on malversation to private individuals. Provided lang, yung matagaya dapat public individuals na to, no? Kini Article 222 nag-extend na isa extension. Provide kay mahimo mo kang public individual ana kung mahimo kang public individual kung mo-consider ka public individual kung ang imuhang gigunitan national, provincial o municipal funds. Marinana ang mahitabo sa imuha ba. So example, in the civil proceedings to obtain a preventive attachment to secure a debt contracted by accused Rastrolio, then a defendant, of whose, among other properties belonging to 1,121 feet of hostesha belonging to said Rastrolio was attached. The attached property remained in the possession of Rastrolio, who, with the consent of the attorney for the plaintiff, sold the same to the Manila Fire Department. Rastrolio failed to deliver the proceeds of the sale to the attorney for the plaintiff immediately after selling the host, and deposited the proceeds of the sale in court after 4 months following the day the complaint was filed against him for embezzlement. Ang iyang decision, if the acts with which the accused is charged constitute a crime whatever, it would be that of malversation of property attached by judicial order. The act would not be regarded as constituting estafa because the property alleged to have been misapplied was not the subject of a mere private bailment but of a judicial deposit. This gives the depository a character equivalent to that of a public official, and breach of his obligation is similar to the violation of obligations imposed by public office. Take note ha, the court said that ang character sa isa ka private individual is equivalent to that of a public official. At this particular point, when you are a depository of a public fund deposited should have been deposited in the judiciary. That would be considered as judicial deposit. Kay wala lang man gipa-deposit sa court, ato lang man sa iya, iyang gi-misapplied, iyang gibaligya, and then wala niya gi-turn over ang iyang halin. Okay, another one, sheriffs and receivers fall under the term administrator. The words administrator and depository include the sheriffs and receivers. Thus, if they misappropriate money or property under their custody, they are liable for malversation. Judicial administrator, not covered by this article. So, yung word administrator. The word administrator here used does not include judicial administrator appointed to administer the estate of the deceased person because he's not in charge of any property attached, impounded, or placed in deposit by public authority. Conversion of effects in this trust makes him liable for estafa. Okay. Another one, private property is included provided it is attached, seized, or deposited by public authority. The expression, even if such property belongs to a private individual, is a sweeping and all-embracing statement so as to include a case where private funds or property are involved, as long as such funds or property are placed in the custody of accountable public officers.